right, should we get started?
Yeah.
Okay, good afternoon. You are joining us today for Winthrop & Weinstein's webinar on Minnesota Earned Sick and Safe Time. So this is a topic about which we're getting many questions, and a lot of employers are anxious to figure out what to do and how to comply. And our goal today is to answer many of those questions to hopefully make people feel more comfortable and confident about how to comply with this new law. Recognizing that the Minnesota Department of Labor is still in the process of giving a lot of additional guidance. And so I think while we have many answers, there are still some questions outstanding and things that everyone's trying to solve, but we're happy to cover all these topics with you today. My name is Laura Pfeiffer. I co-chair our employment department with some of my colleagues that are here today, and I'll let them all give a quick introduction, but I've been at the firm for, I think it's 28 years now. It's a long time, right? Yeah, right, what? Like, anyway, but my practice area is employment litigation and counseling, and I'll let Amy introduce herself and then my other panelists.
Hello, everybody. My name is Amy Dayhoff. I have not been at Winthrop quite as long as Laura, but I have been here 21 years. And my practice is focused on employment and business litigation, and I also do employment counseling for both companies and then C-level suite execs.
Good afternoon, everyone. I'm Mark Peihart, along with Laura. I co-chair our employment group. I think I am on year 26 of practice and 23 years at Winthrop, and my primary practice is employment counseling and representing executives.
And good afternoon, everyone. My name is Rachel Brigger, and I'm an employment counseling attorney here at Winthrop as well. I've been practicing for about 14 years. I've been at Winthrop for almost 10, and I routinely advise on a variety of employment-related issues, state and federal laws, and also help employers draft a variety of policies and agreements.
Yes, and I should say at the outset that Rachel and our colleague Heather Bredesen, who was unable to join today, did a lot of work in putting together some materials. We also have a summary that we're going to send to the attendees after the seminar along with these slides, and so we appreciate both of them very much for helping us with getting these materials together. So, all right, so to start with, I will discuss how we plan to spend our time today, and so here is our agenda. I'm going to start with an overview of the new law, and then throughout the presentation I'll also be sort of moderating. Again, we're trying to view this as a panel, so everyone might pipe in here and there with questions or other things. And so that will be my piece. Next will be Rachel, and she's going to cover earned sick and safe time earnings, or for the time, like how do you earn the time? How do the employees earn that? And there's some specific things you need to know there about ways that you can comply with the law. There's a accrual method, there's a front loading method, there's a lot of details around that Rachel will cover with you. Next, the use of sick and safe time. What do employees, what can they use it for? How can they go about using it? How does all of that work? And Amy's going to cover that. Updating policies and procedures, which Mark is going to cover, and then questions and answers. Some of you did send some questions ahead of time, and so we'll try to address those throughout the presentation. And then there's an ability to send us questions today, and so time permitting, we'll try to answer those as well, and use that time at the end to hopefully do so. All right, so starting with the overview. What is sick and safe time? And again, just as a spoiler alert, the deadline for this is January 1 of 2024. So that is what everybody is focused on. But what is it? So it is paid time off from work that employers must provide to employees that can be used for certain reasons. And as I mentioned, those reasons, Amy's going to go into in detail as to what's a valid ESST reason and what is not. Many cities and states nationwide are enacting or have already enacted paid sick and safe time laws, which provide these additional benefits and protections to employees. So locally here, if you have a company that is in any of these cities, Minneapolis, St. Paul, Duluth, Bloomington, you've already been working through some of these types of provisions.
Or should have been.
Yeah,
working through
right,
that.
true, right. So if you did not know about those, now is the time because it's all going to be essentially superseded by this new Minnesota Sick and Safe Time. So we'll talk about that in a little more detail. There's some provisions that talk about complying with the statutory provision or ordinance that is the most generous, but overall, it appears as if the Minnesota one is going to be most generous, and we'll talk about that a little further. But again, January 1, 2024 is where everyone needs to get into compliance. Our expectation is that the state is going to look for good faith compliance or attempts to understand and comply with the law as opposed to demanding perfection as of January 1 of 24. All of you are ahead of the game because you're already trying to understand and comply by going to this webinar.
That's right.
And so that's what I think we'll want all of our employers to be able to demonstrate if there was a challenge later is what were you trying to do to understand and comply so that your employees could take advantage of these benefits. All right, so what is changing? Again, this is the overview portion of this, and Rachel and Amy in large part are going to go more in depth into the details. So starting January 1, all employees that work in Minnesota at least 80 hours. And Amy will talk a little bit about like how does that 80 hours interplay with other parts of the statute. But if you work in Minnesota at least 80 hours per year, you're entitled to earn sick and safe time. It's paid leave that can be used for a reason enumerated in the statute. And again, Amy's going to go into detail about what that looks like. One question we got ahead of time was, is there an exception for small businesses? Like this could be a hardship, both just the administration of it and the granting of it. And the answer there is that it applies to any individual or business with one or more employees. So there isn't a small business exception, and it also includes nonprofits.
That's what I was just going to say. Yep.
All right, so another thing as to what has changed. This earned sick and safe time is going to apply to part-time and temporary employees. And so that's important to note because sometimes people think, well, why would you need extra time away if you're part-time anyway, right? So you're not needing to get a departure from a full-time schedule, but you're gonna accrue at a different rate because of the part-time nature of it, but it still applies to that. So you can't just assume that people that are temporary or part-time, that you don't need to give them earned sick and safe time. They're going to apply.
And that would be in the context that some good examples of that would be, industries that have a lot of seasonal workers, right? Applying, kids home from college over the holidays between Thanksgiving and Christmas, if they're gonna accrue, if they've worked 30 hours, they're gonna get an hour. And also kids in the summer. If you've got an organization that's hiring a lot of high school kids in the summer. I mean, if they're working 80 hours during that summer, then they're eligible.
Accrue for them as well.
Which is different than a lot of employment laws.
Yes.
So this is kind of an interesting piece to note that's going to kind of come into the policy piece of this that we're going to talk about later.
Yeah.
Exactly. So independent contractors are excluded. Although we can tell you very clearly that we do not think that is the solve, right?
No.
We do not
Properly
recommend,
classified.
so.
You're gonna get into a whole lot of other problems.
Actually, like much more dangerous and more expensive problems if you think that the way around this is to make more individuals independent contractors. If anything, all of us, I think, have found that in the last even 5 years, that there is much more of a challenge to the classification of people as independent contractors versus employees.
Yes.
We're seeing it at the IRS, we're seeing it at the Department of Revenue here locally, we're seeing it in unemployment very regularly, right? So do not, if somebody is truly an independent contractor and you've like gone through the analysis of the factors and feel comfortable with that, that's fine. This is not going to apply to them, but that's not a workaround that we would recommend. If there's temporary employees supplied by a staffing agency, those are going to be employees of the staffing agency for the purposes of ESST, unless a contractual agreement states otherwise. And it does not apply to building construction industry employees who are represented by a union if a valid waiver of the ESST requirements is provided in a CBA.
Laura, I might just add on the staffing agency piece, like this notion or concept of a joint employer. If you have employees from a staffing agency, they're still entitled to ESST, and you just want to make sure that somebody's taking care of that, even though it's their responsibility or it may be the responsibility of the staffing agency. I think it would be prudent to make sure that they're actually providing it.
Yeah, and I mean, that's another, I had a call actually, coincidentally with the staffing agency this morning about some of these types of things.
Oh,
And
interesting.
they were explaining that there are sometimes challenges with the attendance policy of the client.
Yes.
And that the fact that it's their employee, but yet this earn sick and safe time piece, if they want to, if the client wants to rigidly apply the attendance policy, how to manage that with, and so I think that the answer is that it makes sense to have a more fulsome discussion between the client and the staffing agency about how to address that so that, because it is the reality of the law now, right? But it's a bit of a push-pull, it's the client and you can see why the client wants the person there, but yet the staffing agency has to comply with the ESST, right? So how to bridge those things and, try to have a conversation with the client about it.
And I think that's the important piece, having that conversation.
Yeah.
Because a lot of that is going to be covered in a services agreement between the parties, but sometimes not. And I think it's just important to make sure you're having that conversation, at least in the context of ESST.
Right. All right, so next we're going to turn to Rachel, and she's going to address the various methods that an employer can comply with granting employees ESST. But I'm going to start with a question or two to her because it sort of sets the stage with some of them, some of these things as we get into the details about front loading and accruals and what have you. So to start with, Rachel, a lot of our clients have a policy where the individual is not entitled to an accrual or any kind of time away from work at the beginning of employment. So maybe there's some sort of probation or elimination period at the beginning. Is it still possible to have a waiting period like that when somebody's brand new?
Yeah, that's a good question, and that's coming up a lot. So the answer is no. Employees have to be able to accrue and use sick time from the beginning of their employment, and that's different than a lot of just general company policies and also what was permitted under various of the city sick and safe time laws. So it's important to remember it starts right at the commencement of their employment.
Okay. So then here's another one I'm going to throw at you. So you're going to talk to us about for people where like with the accrual, right? That's kind of the first piece. So that's maybe an easier concept to think about if somebody works hourly, right? So if you have a commissioned employee that only gets paid commission, so they don't really work hours in the same way, how do you go about accruing time for them?
Sure. Yeah, this is a question that isn't directly addressed by the statute already. What the statute provides is that earned sick and safe time must be provided at the same hourly rate that the employee earns from their employment, but in no case can it be less than the minimum wage. So employers who have commissioned employees are going to need to find a reasonable and accurate method to calculate what that hourly rate is for their commissioned employees and make sure that they are getting earned sick and safe time that's paid at that rate.
Great. So one thing we should mention is that the Minnesota Department of Labor does have on their website a lot of frequently asked questions. And so we've been studying those. We're also watching them as they have added more information, and I think they'll continue to do so. I know some of our colleagues in this space have been sending questions into the Department of Labor directly for some things that are still unclear or outstanding, which is a possibility too. But just we would encourage everybody to go onto the website and to pull those, because I think they are a evolving but helpful spot to look for additional answers.
Yeah.
All right, so then I'll let Rachel get going.
Great. Well, let's dive into the details of accrual versus front loading. So just as, you know, a sort of preliminary matters to address before we talk about the specific methods, employers have to set their own benefit year for using earned sick and safe time, and they can choose any consecutive 12-month period of time. The parameters that this has to be clearly communicated to employees so they know what the benefit year is. And common examples of this would be something like a calendar year, a tax year, fiscal year, or a year based on the employee's anniversary date. But for purposes of the new law that comes into effect on January 1, all employers either must start accruing hours for their employees as of January 1 or have the full amount of front-loaded hours, either 48 or 80 front-loaded on January 1, 2024. So the accrual method. The accrual method, like it says, is a method by which employees accrue or earn sick and safe time as they work. So they have to begin accruing earned sick and safe time at the commencement of employment. The rate is at least 1 hour for every 30 hours worked, and you can cap earned sick and safe time at 48 hours per year. But employers can also have a more generous policy if they would like. For employees that are exempt, they're generally considered to work 40 hours per week, unless you have like objective evidence that their work week is typically less than that, in which case you can provide sick and safe time at that lesser amount that's consistent with their regular work schedule.
Rachel, we've got a question that I'm just going to jump in and ask because it goes back to this commission sales piece that you were just talking about. So the question is, if we have commission investment advisors who do not get PTO per their employment agreement, we now need to give them paid PTO. And I think the question is, we now need to give them paid ESST. Can you give us your thoughts on that?
Yeah, so again, this is something we're maybe looking for some more guidance on, but if they're an exempt employee or commissioned employee, they need to be provided ESST at that same hourly rate that they earn from employment. So employers need to look for a way to calculate
that.
that.
The 80 hours, right?
Exactly.
Which, you know,
Yep,
right,
assuming that they hit 80 hours.
Minnesota do, right? So
Yep.
so even if they don't receive PTO, they are going to have to have this ESST,
Right.
and then the employers are going to have to come up with the arrangement whereby they figure out what this hourly rate would be, but in no case can it be less than the minimum wage. So it's kind of another category of person that you thought maybe like the temporary employee, like maybe we don't have to do it for them, right? But I think it appears that you know, you are going to have to give them the ESST.
Yeah, and I also would say that you know, we're given no indication, any of the language or background in this statute that there's any ability to contract out of this. So I think that question, you know, was they have this employment agreement that says they don't get this. Well, that's not going to be enough as the statute is currently written.
And I don't think it matters whether you call it PTO or ESST, kind of going back to this question where, you know, it asks, do we have to give them paid time off? It's really, you have to give them ESST, and that can be incorporated into a PTO policy. You can call it that so long as it complies with the requirements under the ESST law.
Yeah, so Rachel, we just
One
got
option
another. Oh, go ahead, finish that thought.
I'm just going to say one option that potentially comes to mind that some employers are using for certain employers is an unlimited paid time off policy, which could lend itself to a situation like this, but you still would need to provide some sort of paid time off to comply with the statute. And there are downsides to unlimited PTO policies too.
That's a great point on the unlimited PTO, because we have a lot of clients that are now moving in that direction. You can still do that. We're going to talk later about the notice requirements that come into play
on the
that.
checks.
But yeah,
Right, yeah, and then on the
Earnings
earnings statements,
Yes.
which you'll go about, at the end, right, to go over. So we got a question, do you start accruing after somebody hits the 80 hours or not? And so can you cover that, Rachel?
Sure. So there is an 80-hour eligibility requirement, but the statute requires employees to start accruing from the beginning of employment. So what we recommend is if you have employees that are in Minnesota that are going to be here and are going to work more than 80 hours in a year, start accruing them right away. Really, from what we can see, the 80-hour eligibility threshold would apply more for the circumstances where, say, you had an employee working in Iowa or Wisconsin who may come to Minnesota from time to time, but you're not sure if they are going to meet that 80-hour threshold, then you could potentially wait to stop or to start accruing for those employees until they reach that 80 hours, and then accrue for the hours that they work in Minnesota if they do become eligible. But again, for your regular employees that are here in Minnesota, you should just start accruing right away.
Yeah, because I think that's a great question, because
Yes.
it's confusing, right?
It is.
Because it's like, well, what's the point of the 80 hours then if you have to accrue immediately and they can start using it, which we'll get to, right? Spoiler alert.
Yeah.
Immediately, right? But I think that's from what I'm reading and hearing, it's that they're trying to not have employers where there really isn't any meaningful, intersection with Minnesota that you'd have to accrue for people like that if they're really not working there. But like if it is a Minnesota employee, given that it says you have to accrue it right away, and then we'll get to using it too, that it doesn't make sense, right? So that you would need to, we recommend that you accrue it right away if they're a Minnesota person, and then allow them to use it as it accrues.
Right, so here are a few more details on the accrual method. So under the accrual method, you have to permit employees to carry over their accrued but unused sick and safe time at the end of the benefit year. However, you can cap the employee's total accrued time at 80 hours. ESST does not accrue if the employee is not working. That's a frequent question. If they're using earned sick and safe time, if they're on vacation, if they're on another leave of absence and not actively working, they don't accrue. And then you can calculate the earned sick time hours at the same frequency as what you normally do for payroll. So whether that's by a pay period, weekly, biweekly, monthly, that frequency is acceptable.
Rachel, before you move on, you mentioned that employers may cap an employee's total accrued sick and safe time at 80 hours. However, employers can have a more generous policy if they choose. Is that right?
Yep, absolutely. And a lot of employers do allow employees to carry over more hours than that. But if you choose, you can cap that time at 80 hours. That is the floor.
Rachel, we got a question in that might be timely right now for me to ask. Sure. I'm going to put it out there, and I apologize if it's something that you're going to address, but will the accrual be considered vested? So is it paid out if the employee leaves? There's a clear answer to that under the new statute, and then there's also some policy considerations. Rachel, can you address that?
Yeah, so I think the vested term isn't really applicable, but it does not have to be paid out at termination of employment. And you should clearly set that forth in your policy. Some companies do like to pay out PTO, so that's something to address if you have a combined policy or separate policies. But once it is accrued, it is essentially available for use, subject to the caps, and you can't otherwise take it away from employees.
Yeah, and some of this we're going to address a little bit later, but this is one of the reasons why I've seen some employers at least contemplating having separate policies, one for ESST and one for PTO. In other words, it's because of this payout piece. ESST, the new law does not require that it be paid out, but if you're lumping it into a PTO policy and, you know, covering or complying with the ESST law in that PTO policy, you may be inadvertently or unwittingly agreeing to pay out a larger portion than you might want to.
Yeah, I think like when we were getting ready for this presentation, what we figured out or, you know, discussed was that it's what's best for a client is really going to depend on their individual circumstances. Like, so some of my clients are clearly going, you know, Rachel's going to talk about front loading. They would not front load because it doesn't make sense for their workforce. Other places where, you know, in that particular client would never have an unlimited PTO. That just wouldn't work for the way they're set up. Other places, you may very much want to combine everything and get them to take it all, right? You know, and really not ask many questions about whether it is or not. And so I think it's the takeaway is that really examining what the options are and your workforce and your concerns, and then coming up with a solution that works and complies with the law, right? Yeah. But I think there's really not a one recommendation for like all of our clients should do X, right? You know, I think that there's going to be differences that would be recommended based on the particular client and the workforce, right? You know, some of the things that you were saying, and then where maybe you have it separate, maybe you combine it. Like it's really going to depend on kind of what the client's preferences and what their workforce is, in that industry. So
I think that's a valid point, and if we kind of talked about this the other day.
Oh my God, I got
You've been validated.
Oh my God, that feels so good.
I just validated you. So I think it's what we're seeing is that if clients legitimately have a concern about abuse of the SST, we're going to talk about some best practices later.
Yes.
If you legitimately have this concern that there's going to be abuse, you're probably going to want to reconsider front loading. And instead,
you probably want it separate, right?
Have it separate and do accrual over time so that you can try to avoid some of that abuse. And there's always going to be abuse in these policies. Many of you, you know, we've told this to you over the years that you can almost expect that employees are going to try to find the ways that they can get around. What's the loophole, you know? But that shouldn't drive your policy decisions entirely. But in this particular case, it is a factor in determining whether you're going to front load or not.
Yeah, exactly. 48 or 80 hours,
All right, so moving ahead to what is front loading? Like, you know, what can you do? What does that look like? Let's let Rachel, you have an example first, sorry. So
yeah, I'll try to move through this really quickly. So just a simple example, accrual method. So employee accrues at the rate of 1 hour for every 30 worked. Say they don't use any sick and safe time hours during their first year, and so they have 48 hours because the employer capped it at 40 hours. All of those hours get carried over to the next year. The employee would then keep accruing during the second year, but when they reach 80 hours in their bank, they would stop if the employer has that in their policy, that cap. And then if they still don't use any their second year, those full 80 hours are carried over to the following year.
Yeah, I think we did get a question about that carryover piece. So this example may have covered that. All right, so now moving to the exciting topic of front loading. So, you know, what does that even look like? What are the options? And again, like some employers may prefer this due to ease of administration, and a lot of them, so Rachel's going to talk about like, why in the world would an employer ever want to front load? Doesn't that seem dangerous? Doesn't that seem like that somebody's going to abuse the time and be out all the time immediately? So, but Rachel will cover that and tell us what it even is.
Sure. So front loading is what it sounds like. You're going to load all of your sick and safe time hours up front to the employee at the beginning of the benefit year. So you'd provide them with a lump sum of that earned sick and safe time at the beginning of the year, the commencement of employment, and no carryover is required with the front loading method. Minnesota has a difference in their law compared to some of the city laws in that it provides that if an employer wants to pay out sick and safe time at the end of the year, which is not required, then you only have to front load 48 hours that year. If employees are not paid out that sick and safe time at the end of the year, however, then you have to front load 80 hours at the beginning of the year. So this kind of goes to Laura's question is what are some of the reasons why someone would want to choose this front loading method? And some employers like to choose it because they don't have to track the accrual or carryover. You don't have to carry over hours from year to year. So it makes administration but easier, reduces the calculations regarding accrual and the required record keeping for each pay period. So that's just simpler for some employers. Other employers are going to want to use the accrual method because it limits the amount of time that employees can use upfront, either at the beginning of the year or at the beginning of employment. So if you are in an industry where you might have a lot of employee turnover, you might not want to be providing 80 hours of sick and safe time upfront to employees on their date of hire because they might use all of that and then leave 2 weeks later. So in that case, you would have to track the hours, which is more administration, but it might better fit your business to use the accrual method versus front loading.
Yeah, I mean, I was just talking to a client yesterday who does have concerns, like real concerns about abuse of this, right? You know, not that other people don't, but, you know, just based on the, based on their workforce. And, you know, they were adamant that there was no way they would ever front load, right? You know, which makes a lot of sense, right? And that's why I was saying, like, you know, maybe for our law office, like, we might find it easier. And we feel like people are, maybe there will be less concerns about abuse generally, like, but in a place where you have a lot of turnover and a lot of people working kind of fewer hours, that may not make sense at all, right? So that's why
I'm concerned about the two.
Yeah, well,
yeah.
I after this presentation,
We
I know,
have
I
unlimited
know,
PTO, what are you talking
yeah,
about?
I know exactly how to use it. Yeah, they're just gonna put unlimited on my earnings statement and then,
All good.
yeah, like get back to work for us. So, okay.
A quick question for Rachel too. Rachel, we have a question about carrying over ESST, but if they get PTO that cannot be carried over, is that okay? And I think the answer to that is yes, if you have two separate policies. Do you agree with that?
Right. Yep. If you have two separate policies, you could have PTO, use it or lose it, not carried over. But you just have to meet the requirements of the earned sick and safe time statute. So whether that's through provision of the sick and safe or PTO, you have to allow employees to carry over that 80 hours per year if you're accruing.
We've had a couple participants ask about the materials. So following this presentation, I believe later today, we're going to send out an alert, and it's my understanding that we're also going to make available
The slides.
The slides, yeah.
So.
Yeah, so we have an e-alert that our colleague Heather Bredesen put together that is very helpful that we'll send out to the participants along with all of these slides. All right, so I think we have a front-loading example just to maybe, yes, right.
This gives you great pleasure.
It does.
It does,
Really
yes.
straightforward.
So Mark has to work for us now.
Yeah, Mark works for us. So Amy's a business owner and she employs Mark, and she decides to front load him 48 hours of paid sick and safe time into his bank at the beginning of the year. Because she front loaded 48, she has to pay him out that 12 hours that he has left at the end of the year. But then the next year she decides to front load him 80 hours at the beginning of the year. And in that situation, she's not required to pay out unused sick and safe time at the end of that year and for every year going forward that she front loads 80 hours.
If I would switch back, Rachel, for whatever reason, I decide, oh, I don't like this 80-hour front loading, and I switch back in year 2026 to the 48 hours. If he doesn't use it, I have to pay it, right?
Right. Yep. That's correct.
All right, so what happens upon separation? I think we covered this to some degree, like spoiler alert, right? I think one piece of good news for some of our clients is, you know, you don't have to pay it out on termination of employment. But can you explain some of the rest of this to us?
Yeah, pretty straightforward. If employees are rehired within 180 days of separation, Their previously accrued earned sick and safe time that hadn't been used must be reinstated. And then there are also certain details, like if an employee gets transferred to another division of their employee or how they need to retain their sick and safe time. But a common question, again, you don't have to pay out earned sick and safe time on termination of employment.
Yeah, at our corporate shareholder meeting yesterday too, we also discussed like that if there's a transaction, so an M&A
Yes.
transaction.
Oh, yeah.
Yep.
A lot of times, like maybe the PTO would go forward if that was the desired outcome of the two parties, and or maybe not, and they would just start anew at the new place. But if there is a transaction and the employees are retained by the new buyer, you have to carry forward the earned sick and safe time.
And I think that there's another caveat to that. I think that if the new co comes in and the employees are terminated, but some of those employees and or all of them are rehired within 30 days, they
Right.
also get
Yep.
that accrued.
Right,
Yeah, so
yes.
there's this kind of limited exception too on the hired back within 30 days.
Yep.
Right, so just something to be thinking
Yeah.
about if they're, if you are on either the buy or the sell side of the transaction.
And Rachel, real quick, we got another question. It's asked, with front loading, can you calculate actual earned time when they leave? And I don't think there's any reason why you couldn't. What do you think about that
I'm not
question?
sure I'm understanding the question.
It just says, with front loading, can you calculate, quote, actual earn time when they leave? And I think the only reason, you're not gonna pay out unless you're paying out under, so I don't know
I
that
think
you
it
would need.
depends maybe on whether it's 48 hours versus 80 hours, that's front loaded. If I'm
So-
understanding
But
the
I think
question.
When
termination.
anyone leaves, they're
They're
not
not
getting
in-
paid, period.
No,
Yeah.
you get 48
So-
or 80, it's only if
Right.
they're still
You can't
employed.
really go back and forth and change your method mid-year. So if you're going to choose to front load 80 hours, that's what the employee is going to have in their bank for that year.
Yeah, so there was just a question
Yeah.
like about the PTO being paid or the earned sick and safe time. So if you decide to keep the time in separate buckets, and you want to be able to pay out the PTO on separation of employment, because that's what your policy sets forth, you can do that and not pay out the earned sick and safe time, because the law makes clear that you don't have to pay it out upon termination of employment, but you would have to have those two separate buckets.
Yeah.
So.
Right. Yeah. There's one more question here that I thought would be helpful to really quickly address, if you don't mind.
Sure.
So there's one that says, can you accrue hourly employee and front load
Yep.
for salaried employees, or does the policy need to be the same for all employees? So you can have different policies for different categories of employees, so long as each of them meets the requirement of the earned sick and safe time law. And with any policy, so long as they're not administered in any discriminatory manner. But I think this might be a common approach, just to have two different types of policies for different categories of employees.
Right, so as long as it was applied to all similarly situated people,
Right.
right? But you could,
Yeah.
If you thought that made sense, have one policy.
Yeah.
Maybe you're front loading for the salaried employees or the exempt employees, and you're accruing for the non-exempt employees, right?
Right.
Again, recognizing just different categories of employees, different concerns that you might have. Maybe some of the exempt employees have unlimited vacation already, and you're just incorporating that in a way that makes clear that it complies with the earned sick and safe time, but that is permissible. All right, so now we're going to turn to Amy, and she's going to talk about the use of sick and safe time. What does that look like? How do you go about taking it? Are there notice requirements? What does that look like? So, all right, Amy.
Hey everybody. So basically employees can use their earned sick and safe time as it is accrued, which you've heard about through the course of this presentation. So there's no waiting period if eligible. And one of the things that I want to address, we got a question on, is this concept of who is really eligible. And so there was a question of, does this apply to employees working remotely from another state and do not work in Minnesota at all, even though the company is located in Minnesota? And the key is, are they spending 80 hours of time working in Minnesota? So the answer is no. If they're based in North Dakota, all their work is happening in North Dakota, then no. They are not, you're not required to fulfill the ESST statute. However, if you are, let's say you're a Minnesota company You have locations in Wisconsin, so we'll use the bordering states, and that the individual lives in Wisconsin, but is coming to headquarters because of their job duties for over 80 plus hours, then yes, they are eligible for this, and you need to make sure that they are provided the ESST. And the question is, well, if we have a lot of, we're a Minnesota company, but have we work in lots of different states, should we just make everybody eligible for ESST because it gets too complicated? I think that that's going to need to be a business by business kind of case decision, depending on your industry, and if you've got a lot of people that are coming from your locations in Nebraska, Wisconsin, North Dakota, anywhere in the Midwest, and spending quite a bit of time in Minnesota, it might be easier to make it a blanket policy. But I would encourage you to call your employment counselors and us or whomever to talk through that situation. So,
but Rachel, would you say it's fair to say that most of our clients, like that have, Michigan policies or other ones where sick and safe time has been on the books for a while, that they're not really having blanket policies, right? Where most of our clients are complying where they're required to because of some of the concerns about abuse and otherwise. I mean, do you think that's a fair statement, Rachel?
Yep, I do. Yep, I agree.
I think it's interesting though in this world of remote employees right now where, okay, I'm a Minnesota employer, but I've got a bunch of employees working outside of the state of Minnesota, so I'm not even going to concern myself about this or worry about this. I guess two things, and to your point, Amy, if that remote employee is coming to Minnesota on a frequent basis, then you still need to be mindful of tracking.
Yeah.
And second, to this question, Laura, or this issue you're talking about, there are other state laws. We're not the only
That's
state
right.
to have ESST.
I think
So-
we're the 18th, is that right? Plus the Washington and District of Columbia, I think. So yeah, it's
So yeah, you
becoming
just
more
wanna,
common.
you don't want to be dismissive
Yeah.
just because, oh, they're not in Minnesota, I'm not going to worry about it. Just make sure that you have at least done your due diligence and okay, they are in this other state, even though they're working remote, I may have to comply with that state's law as well.
Right.
Right, so but taking this a little bit further. So Rachel, with the example that Amy just gave with like mostly in Wisconsin, but then hits the 80 in Minnesota and maybe works a little more in Minnesota, you're only accruing based on the Minnesota work though, right? You're not accruing based on all of the work in Minnesota and Wisconsin. Is that correct?
Right, you'd only accrue for the hours worked in Minnesota. That's something that was recently addressed in the Minnesota Department of Labor frequently asked questions. So that's helpful that they.
Yeah, so I thought that was helpful to make sure you're remembering too, right? It's just like once they hit it, they're only accruing based on the work performed in Minnesota, not based on all of the work they perform in either state.
Right, and I
It's kind of a
understand.
burden, though.
That's what I was just gonna
You
say.
gotta
To the
track-
employers are sitting
yeah.
here like, how do I do this,
And
right?
this is why
Don't ever
the
come to
unlimited
headquarters.
PTO policy.
Yeah, you do not come to headquarters, we'll come to you.
Yeah. This is why employers use unlimited PTO
Yes.
and have other,
Right.
types of policies like that, they're
Yeah.
all inclusive.
Yeah, exactly. Okay, and so the statute is for the employee's own use or to care for a family member's mental or physical illness, injury, or need for preventive medical care. It also covers absences due to domestic abuse, sexual assault, or stalking of the employee or a covered family member. So there's a lot of things that it covers, so I'm gonna try not to completely read off these slides, but it's important for you guys to kind of understand what the covered areas are. Closure of the employee's work due to weather or a public emergency, or need to care for a covered family member. For instance, you've got kids and their school closes or their daycare closes due to weather or public emergency, that's covered. So, the perfect example is employees that are staying home because of snow days. And employee is prohibited from working or teleworking because the employer prohibits them from going to work because of health concerns. They may have some communicable disease. Look, we just all went through COVID, right? So God help us that hopefully we don't have another one of those kinds of outbreaks, but it would be in a situation like that. Or if they're seeking or awaiting some type of diagnostic test as well, that also is covered. The other one is basically if health authorities or a healthcare professional says that the presence of the employee in the community would jeopardize the health of others due to the exposure to communicable disease, whether or not the employer or family member has actually contracted the disease. I think that, this is one of those that hopefully we're not gonna run into, but there's obviously been a lot of thought put into it, and I think that we probably wouldn't have seen this if this statute would have come into play before COVID. But I think that this is a knee-jerk reaction to COVID. So translation would, can you use sick and save time for exposure even though you or the family member may not be ill? And the answer is yes.
Yeah, so we had a question about this. So
Well,
what
definition,
what does family member mean? Right?
So here we go.
here's-
And it's one of the things I want to point out right out of the gates, it's a very broad and expansive definition. So obviously your typical family members, your child, your spouse, siblings, parents, grandkids, grandparents, but it also includes nieces, nephews, aunts, uncles, foster and step relatives, any other individual related by blood, or whose close association to the employee is the equivalent of a family relationship. Now, I am sure there are going to be a lot of questions about what does that mean. I don't know that we have a whole lot of guidance on that right now.
And I think you'll have to accept it at face value.
You will, right?
And like that's the
Yeah, how are you gonna-
intention, right?
exactly.
This next one is even more encompassing.
Yeah, up to one individual annually designated by the employee.
We refer to this as my neighbor's sick.
Yeah, I mean, so that's how the statute reads. Again, there's not a lot of guidance on that. I haven't seen any guidance, frankly, from the DOL or
I think
anywhere.
just
You guys
this
have?
is the definition so
Yeah,
far, right? And
yeah.
I think overall, you'll need to accept at face value if, there is this in that second to last bullet point, right?
Exactly. And so the employee notice, and this is where I think there's a lot of consternation amongst employers, and rightfully so. You can require, as the statute allows you to require up to 7 days of advance notice for foreseeable use of ESST, right? So you got routine medical appointments, that would be the first thing that would come to mind with regard to that. And if the need is unforeseeable, which we know a lot of times, if you look at sick time, that is unforeseeable things that happen, employees may give notice as soon as is practicable. And that is the language from the statute. The notice requirements of the employer have to be in writing and provided to the employee. And Mark will get into some of that later related to the employee handbooks. But one example I wanted to give is, let's say that Laura has used ESST for 4 consecutive days. And let's get to that nice slide. So, okay, this is where I want to go with this. On reasonable documentation, when an employee uses the ESST for more than 3 days in a row, what does that mean? And so this is where it gets a little interesting because the statute says it may include a signed statement from a healthcare professional, or the employee may provide a written statement that ESST was used for qualifying purpose. So my example was Laura is out for 4 days using ESST. And she's gone past that 3 days. And for whatever reason, Laura has not been in to see a healthcare provider, whether it's the expense of it.
Yeah, maybe
She's
don't
so
have
sick.
one, or
so sick she
right.
can't even drive herself, whatever the
Just
case may be.
expense, right? Like
Yeah.
like a lot of employees don't have a general medical provider. And
That's
they're
right.
worried, their insurance maybe doesn't
Cover
cover that, so that it's it would be a real reason why somebody might not seek
Right.
medical care.
So in that situation, Laura, pursuant to the statute, can herself submit in her own writing and in her first language. That's the other thing that you need to know. So if you have a diverse workforce and their first language is not English, they can submit it to you, Spanish, whatever it is, and that's sufficient notice under the statute. So wanted to make sure to get that example in there. Let's
Do you
see.
want to catch that
Yeah.
increments of time real quick?
Yes,
Because
question
that-
on that too,
Yeah,
yeah.
because that is one that I have had questions about.
Yeah,
as well,
and so they may, ESST may be used in the smallest increment of time tracked by the employer's payroll system. However, that increment cannot be more than 4 hours. So it can be less, so it can be 1 hour or 0.5 or whatever. It cannot be more than 4, but it can be less. But it's got to track with the employee's payroll system. The other important thing is that you cannot require that the employee find a replacement worker. And I know that happens in certain
It's in a lot of policies too,
It sure
right?
is.
That
It
you
sure
should
is.
find somebody to cover your shift.
exactly,
Right?
and that you cannot require that under the statute.
But you could ask though, right? I mean,
Yeah,
you could encourage employees to find somebody to cover their shift, but you can't require it.
Right.
I mean, that's the.
And that's a fine line.
Right.
It
So
is.
I've got a question here that is kind of on point that I'm gonna ask Amy, and are we able to allow employees to go into a negative balance of ESST? So the answer is you're not required under the law to provide ESST if somebody's
Have it-
exhausted
yeah.
the accrued amount. And don't forget, if you're front loading, then they've got all that, in theory, they've got it
Right.
all available on the front end. But you're not required to give them extra time such that they would go into a negative balance. You certainly can. And if you've got one of these combined, all-inclusive,
Yep.
all-in-one policies, your PTO policy, for example, may already address that and you may allow for that. So just make sure that you're being consistent across the board with what your policy says. The reality is if you go negative, as is the case with almost any type of paid leave, you kind of run the risk that you're not going to get that money back if the employee then decides to leave with a negative balance.
Yeah.
Yeah, I mean, it seems to me maybe that another way of going about it is like, so say somebody's exhausted everything.
Yeah.
Right, so like maybe you even have everything's all in one bucket, right? So I took a big vacation at the beginning of the year. I then have that covered almost everything. And then I have
An ESST.
an ESST event.
Yes.
And I'm out of it, right?
Yes.
So at that point, I'm not entitled to be out any longer because I have exhausted everything, right?
Yeah.
But at the same time, like, I'm a terrific employee. I mean, I know, everyone knows that, but so you want to retain me. I don't know that you would put me in a negative ESST situation. Maybe you would allow for just additional unpaid leave, right? That's being evaluated until I can come back, right? So it's a little different than allowing them to go negative per se.
Yep.
But these are all things to kind of think about. All right, so we're getting a little close to the end of our time,
Yeah.
so we want to make sure we
Yeah.
cover everything.
Yeah.
So this one's pretty easy.
Yeah,
right?
obviously you can't, discharge, penalize, threaten, restrain, retaliate, or discriminate against someone if they use it or request a statement of their ESST amounts. You cannot, as employers, count ESST as an absence that may lead to adverse action under their absence control policy or your attendance point system. However, I would say the caveat is if you're on an accrual based method and the employee is only accrued 5 hours, but they take 8 hours, I would argue that you can dock under if you have an attendance policy for those 3 hours that they had not
For
accrued
the
for.
ones right
Yes.
afterwards.
Yeah.
So
And I know a lot of people on this call do, attendance-based points policy. So I think that's really important to point out.
I think it's a best practice question here is, if you've got somebody that has shown a pattern and practice of abuse, then that would make sense. It's kind of that slippery slope though, when you start penalizing somebody for a leave that was partially covered under ESST. It kind of goes back to what you were saying earlier, Laura, about is this a good employee? Is this somebody who is truly sick or needs the time off versus somebody that is
Right.
perhaps has a history of Friday and Monday absences, where it looks like they're abusing.
yeah.
So it's kind of
I guess the rejoinder to that though is that, you want to be consistent,
Yep.
right?
This
Because
is-
otherwise
exactly.
it looks like, that's the whole point of an attendance point policy, right? Is that like, we're doing it and this is how it works and right? And
Right.
so then there's
Yep.
like no challenge to it because we're clearly doing it, right?
And
Yeah.
that's the issue, that if you do it for the problem employee, you gotta do it for the good employee
Yeah,
also.
exactly.
Yes.
Yes.
So just being thoughtful about that. All right, so Mark's gonna close us out with updating some policies and procedures and what do people need to be thinking about?
Great. Well, okay, so Laura and Rachel and Amy gave you a lot of good information. So now these are kind of the takeaways. So the first piece, we talked a little bit about this already, is the employer notice piece. And again, just a reminder, this applies to all Minnesota employers. So if you've got any employees in Minnesota, this applies to you. You have to give written notice to all employees who are entitled to the ESST. And this includes, the written notice has to include the amount of the ESST available, the accrual year that you're using, the terms of use, the requirements for providing the notice, a statement that there will be no retaliation for requesting, and I'm going to say legitimate use of ESST, but that's slippery slope again.
Yep.
And then finally, you have to provide in the notice that the employees have the right to file a complaint or bring a civil action for denial of ESST or if there's a case of retaliation. This was mentioned earlier, but it's also worth repeating here that the notice has to be provided in English and the primary language of the employee, if that's been identified by the employee. And it has to be, remember this law goes into effect on January 1. So for all of your current employees on January 1, you've got to make sure that they get that notice or at the time of hire.
Yeah, and so we just got a question about a model notice, and the Minnesota Department of Labor is putting together a model notice, and if it's done the way they've done in the past, they've done it in different languages
Yes.
too, right? So that's where I think I would direct people for a model notice.
And I expect that that'll be out here sooner rather than later, knowing that the law goes into effect Jan. 1.
We hope.
Yeah, well,
Yeah, right.
So let me just address that point right now, if you could.
Yeah.
Next slide. I'm just going to address that now because this is something that has come up recently also. On the employer notice piece, where does the notice show up? Well, it can certainly, it has to be one of the following. A copy that is posted at each location where the employees perform the work. Just a reminder about the remote employees that we talked about before.
Right,
Making
yeah.
sure that, you've got that covered as well.
Yeah.
Providing a paper copy or an electronic copy to employees. The electronic piece, I would just, again, caution you that in a perfect world, the best practice would be some type of acknowledgement that the employee has actually received it.
Great.
And then, conspicuous posting in a web-based or app-based platform. So think, for example, a company web page or an intranet page. So if you have a handbook, the statute also says that you have to have a notice in there, and it talks about a notice of employee rights and remedies. And what we believe this means, and it's a little lacking on thoroughness and guidance, but this notice, this model notice that the two of you were talking about that's going to come out from Dolly, you could potentially in your handbook have a general reference to your ESST policy that you're going to provide it in compliance with the applicable law. And then you have the details, because remember the devil's in the details with this, and you have to provide that detail. You could have the employees receive the separate Dolly notice that has all the details in it. More to follow on that, but this is what we think it means right now. Can you hit the next one of these things? So earnings statements, this is another key piece. You have to keep accurate records. For Minnesota employers, you got to do this anyway. This is the law, but as it relates to ESST specifically, you have to keep accurate records documenting the hours worked by the employees and reflecting what's accrued and what's been taken. And this is supposed to show up on every pay stub now. Plus, employees have the ability and the right to review those records at their request. And I'm talking about records that apply to them, not anyone else's records, but an employee has the right to request that review.
And that one goes into the unlimited. So if you have unlimited PTO, what does that mean? And as of right now, we don't have guidance directly from Dolly on that, but the thought is if you just put unlimited
On the earnings statement,
that it's going to cover you.
Suffice.
Again, this is, making your best good faith effort at this point in time. I mean, but I know that's going to come up as a question.
We don't know for sure, we
Uh-huh.
think, but I think we'll get more guidance on that.
And
So-
what I've been telling clients too is that to try to get ahead of this a little bit because, if you're working with your payroll provider, right? Okay, so
Yes.
we're gonna need to make sure we're adding some things to our earning statements. What do you need from us on that? What's the timeline on that? Because this is January 1, since some of that will be coordinated with a third party, if that's how you handle your payroll, right?
Yeah.
So,
Just a couple following points here. We've addressed this quite a bit, but I'm just gonna restate this because it's important for the takeaway. Can you have a one-size-fits-all policy with respect to ESST? Specifically, we're talking about PTO policies. Absolutely you can. Again, the key is that policy has to have the required language in it so that it's compliant with the new ESST law. Next slide, please. There was reference earlier about everybody has to comply. So this is true for organized labor as well. If you've got a collective bargaining agreement, you got to make sure this is addressed and it's got to fulfill the minimum requirements with one very small, very limited caveat, which is that if it's a CBA with a bona fide building or construction trade, then it can be waived so long as it was knowing and clearly identified. All right, final thoughts here, multi-jurisdiction. We touched on this earlier. We've got these 4 cities out there already. You have to give the most generous application of ESST to your employees wherever they're located. As of right now, what we can tell you is this. The new Minnesota law is the most generous within the state of Minnesota, meaning Minneapolis, St. Paul, Duluth, and Bloomington are less generous. As of right now, those ordinances could certainly change, or we could have others that jump in.
Some of those cities are changing.
They
to
are.
ramping up
to get there, yeah.
Yeah.
Right, so that might solve that too.
Yeah.
Just because otherwise it was kind of confusing.
It was.
So the most generous has to be given, and then just kind of a note for multi-state employers here. Make sure you're aware of those other ESST requirements in those respective jurisdictions. Okay, common policy changes. Again, we're here to help with the review and revisions if necessary, and these are some of the things that you really want to make sure you're looking at. It has to be provided to all Minnesota employees, including part-time employees and temporary employees, so you want to make sure your policies reflect that. The new law requires the carryover of at least 80 hours and requires use in the smallest increment, as Amy talked about earlier, so long as that smallest increment is not more than 4 hours.
Yep.
Policies need to reflect that. And you can't penalize an employee under an attendance point system for use of that ESST. So again, you want to make sure that you're checking those policies to make sure that you're not missing something there. So again, we're here to help, whether it's just a review of what you have, creating something from scratch. There's a lot of that's going on here, a lot of pieces to this. And it is certainly important to make sure you've gone back and reviewed all of your policies and procedures, not just a PTO policy, but everything else to make sure you're not in violation.
Yeah, and also those wage notices that you know,
Yes.
a lot
Yes.
of
Yep.
clients, that's been a requirement for a long time, but some people still haven't been doing that or don't remember that. So don't forget the wage theft law and making sure that wage notice is provided too, that includes this information.
Yes.
But and as Mark said, we are happy to help. There really isn't one universal recommendation of how to do this because, like I said, some clients may have different preferences based on their workforce and what makes sense. And so that's all important things to think about so that employers are making the best choices to comply with the law in a way that fits their business.
A real quick question. Somebody asked that they wanted to confirm if you have something very similar to in our call, it's called a different thing. Does it need to be changed to be called ESST? No. The statute or the Dolly regulations that are FAQs have made clear that no, it doesn't have to say earn sick and save time. Your policy doesn't. So I wanted to make sure and get that one addressed.
Yeah, but you do need to make sure that it's clear that whatever it is called, that you can use it for all of the reasons set forth in ESSTs.
Right.
I thought a couple of questions. The slides will be sent to you if you didn't hear that already, as well as an e-alert that we have that summarize things as well.
And if you have some other questions, like Mark said, we're happy to, answer those. Shoot us an email, give us a call, and we'll try to help you navigate this very, very complicated statute.
Yeah, but otherwise I want to thank everybody for participating and everyone on the webinar for joining us. We hope you found it helpful and have a great rest of your day.
Yeah, thank you.
Thanks,
Thank
everyone.
you.
Bye.
you.
Okay, that was great.